All right, so welcome everyone for today's panel discussion one. So we are waiting for Karim. All right, participants. So let's start with our first panel discussion for today's conference. So the topic for the first panel discussion is protection of IP rights, issues, challenges, opportunities, and solutions that lie ahead. We have Dr. Aaradhana Sadasivam. She's a senior manager, IP, Temasek Life Sciences Laboratory. We have Heather Bowen. She's a commercial counsel from Six Sense Inc. We have Tsen she's a general counsel joining from Amcor Flexibles Asia Pacific. We have Karim Elhelaly, and he's not joined yet, but we're looking forward to have him. He's a legal director with Oracle Systems. And our moderator for today's session is Lijun Chui. She's a partner with Bird & Bird ATMD. So over to you, Lijun.
Thank you, Mitali, and thank you and welcome to everyone who's joining us for this panel discussion this morning. So our sort of focus topic here is really protection of IP rights, and as a nod to what's going on and affecting us in the world right now, we thought we might just kick off with the discussion around pandemic-related challenges. And the initial sort of idea was to have Karim talk generally from his perspective. But I think perhaps what we'll do instead is go into the nuts and bolts of the problems and the logistical issues of IP protection, given where we are and essentially the lack of accessibility in terms of perhaps legalization and execution of documents. So with that, I think the person who might be best placed to share experiences and insights with us would be Lily. So Lily, if you don't mind, perhaps you could share with our participants, I think, some of the issues that you have been confronted with, and perhaps some of the workaround solutions that you found most efficient for yourself and your organization.
Certainly. Thank you, Lijun, and thank you very much for the introduction earlier as well. So, I mean, indeed, one of the biggest logistical and operational issues and challenges, which I think lawyers have faced, and I can probably say this holds true not only for IP-related matters, is in relation to the execution and legalization of documents. As people would know, whereas in the past, the preferred approach has always been, in order to ensure legality and enforceability, we would have original documents printed and signed in wet ink. Now, the issue of the pandemic itself has certainly thrown up a number of issues with people now working from home, not having access to printers, mail, or even couriers. And even when people are able to go back to the office, the fact of there being team segregations and physical contact limitations really means that people can't necessarily cross paths to sign documents simultaneously. So I know that there's a number of countries that have put in place specific regulations to deal with this by, for example, allowing for more frequent recognition of electronic signature of documents. But this approach hasn't been taken by all countries. So that still presents somewhat of an issue and a challenge for us to overcome as we move into this new year. And I think that perhaps tied in with the remote working and social distancing challenge too is, and now the more limited ability to arrange for example, two directors or an authorised signatory to appear before someone like a notary public to notarize a particular document. And then again, tied again to that issue is the fact that we're seeing substantial delays with actually being able to secure appointments with the relevant government officers for the purposes of things such as notarization and apostillization. So, I mean, I've got two matters that I'm currently working on which require affidavits for an Indian hearing to be notarized and apostilled, and whereas in the past it may have taken, say, 2 weeks to complete the process in totality, we're now looking at that 2 weeks as being the minimum lead time even required to secure appointments with the necessary officers. So one of the things that we've had to do is really try to manage the stakeholder and court and tribunal expectations of the other side. And that's really essential in this day and age when we're certainly seeing delays from our end with regards to getting documents signed off. And I guess the other thing that I wanted to mention in relation to operational issues is obviously relating specifically to IP, the closure of IP offices or otherwise delays associated with their limited operations in a number of countries. And this has meant that, typical tasks such as, for example, filing an opposition to a trademark does take considerably more time to plan in terms of your strategy and approach towards protecting your particular mark and brand whilst you await even a response from the office. And this is where it's really important to make sure that you have sound practical guidance in relation to stakeholder communication, whether or not your organisation can continue to use a particular mark, for instance, in the marketplace whilst you're awaiting, the outcome, etc. So, I mean, that sort of gives you a flavour for, some of the, I guess, some of the operational logistical challenges and issues that we've certainly seen in recent times, specifically arising in relation to the COVID situation.
Thank you, Lily. So I think at Bird & Bird, we certainly received a lot of inquiries, I think, when lockdowns were implemented around the execution and legalization of documents, which is a fair enough question. And I think there would be differences. I think there's a key difference between extremely sophisticated and developed infrastructure and economies where digitalization is an option at all versus, I think, perhaps less sophisticated infrastructure and economies where digitalization might not even be an option. I think just depending on the kind of equipment that might be available to the persons and depending on who's actually executing the documents. So Absolutely. Like you said, that's one part of the problem. And then the other part of it is even where you have the means of doing so, would it be legally recognized? And it's a bit of a patchy situation, like you said, depending on the jurisdictional approaches. So we've been required to give a lot of advice on that end. I was just wondering, Dr. Aaradhana, would you like to share any of your experiences, I think, in terms of any patent-related applications and the like, and, the sort of more logistical and practical issues that you have encountered?
Hello.
Yes, we can hear you.
All right. Actually, I cannot see you, Lijun and Lily. I cannot see you, so I was... So regarding the patents, actually, I'm in the patent prosecution space, and I come from an R&D, and I'm actually presenting my own views, my own experiences. So from patents prosecution point of view, we always have to look for the new markets because of the COVID ongoing restrictions, border closures, and all those stuff. So we get to execute a number of documents, for example, if you go to UAE, Saudi Arabia, and some of those Middle East countries, you have requirements to notarize as well as legalize documents, which is quite time consuming, or at least in the present context, in the light of the ongoing restrictions. The consulates open for a very short period of time or open only in the specific days. So it's very difficult to get the appointments. Earlier, as Lily mentioned, it was just possible to take just a couple of weeks and we could have the document notarized and legalized, ready for submission. But now it takes more than 2 weeks and even longer. So the only solution that I can think of is to execute general documents where possible and where it is acceptable. And the opportunities that it creates, I can only say that we get to network with the multiple lawyers, multiple notary, attorneys who can actually are available on time and they are able to execute the documents. That's the one thing, and it's kind of a really long wait for us. And earlier it was just keep looking and familiarize yourself. That's the other alternative, is just keep looking for and familiarize yourself with the new market so that in time you are more familiar with it. You can predict the time that notarization or legalization may require, and then you're kind of mentally prepared and you kind of organize yourself better way. That's one thing, in relation to executing the power of attorneys, for example, the document of assignments and all that we have to encounter. Yeah.
Thank you. So that's been very helpful, and maybe perhaps at this point we can switch gears a little bit and talk to Heather. If you could share your experiences around trademark protection, because I understand that's your specialty. I mean, what are some of the issues and challenges that you see brand owners facing with trademarks during these rather challenging times?
Definitely, and I think that there's really a number of issues that have centered around the registration of trademarks and even the litigation of those marks that a lot of the brand owners are facing. And, not only in this time, but they'll continue to face during the life of this pandemic. And I think that there's one area where I think many entities are struggling, and that's really in trying to alleviate the risks and challenges of making sure that their trademark registrations aren't invalidated based on a lack of genuine use. And I think for many jurisdictions that require brand owners to use trademarks in a manner that could be, deemed genuine use, and this could be satisfied, of course, by just creating goods and services, putting them into the marketplace, seeing that consumers are actually taking advantage of these goods and services, but also just really finding a way for these trademarks to maintain that significance over a period of time, and just making sure that third parties don't try to come along and sort of cancel or revoke or otherwise oppose the registration. And I think where there's where a lot of the industries that are suffering are particularly with, restaurants and bars, even in some instances with like hair care, hairdressers and salons, where a lot of these places had to shut down during the lockdown period and weren't able to open or somehow take advantage and make use of their business, their brand, to consumers, where you need to have that in-person contact. And so those businesses suffered from just not being able to be used in really any way. And so I think that with those kind of examples, the longer that these establishments remain closed, considering, we're still in the pandemic, can't really see an end to it, really the more time and opportunity that those gaps of time present for third parties to really come in and make a claim of non-use for these brand owners.
Do you think an argument can be made that, given the challenges and difficulties posed by the pandemic, it's not entirely realistic for businesses to remain open? In other words, sort of a grace period, in recognition of the lockdowns that have been imposed. I mean, especially for businesses that are more reliant on brick and mortar presences. You can't expect anyone walking in, and indeed it would be extremely irresponsible to do so. So it seems that, there could be some recognition of that in terms of determining whether there's been genuine use or use, out there being in the marketplace that's critical to the registration of one's trademarks.
I think definitely, I think that there, especially in some jurisdictions, I think even of, I think UK, where they provide like a 5-year period of time before you can actually, put forth this claim of non-use and essentially invalidate a trademark. But in theory, it really seems like such a simple fix. Just, okay, figure out a way to make use of your brand, provide some services online or in some other instance so that you can, say essentially that you're making a genuine use of your trademark. But I think brand owners also have to think about the risks and weigh those against the products and services, the opportunities that they can provide in a pandemic. And so it's like, do they have the capacity and the capabilities to revive their products and services that maybe even during this period of time have been sitting on the sidelines and haven't really been taken advantage of? Or, maybe some organizations and entities might be able to do that, but then also, what are the risks and benefits or the pros and cons that brand owners have to weigh in determining whether or not a cancellation or revocation of those trademarks and the applicable rights that go along with that, how might that impact the business long term and their daily operations if now the trademarks that they relied on in the past have been invalidated and they can't make use of them. So it's a really tough position for where I think a lot of these brand owners are, and just trying to figure out how do we take what made us successful in the past and somehow maintain some sort of semblance of existence for that during this pandemic, so that once we come out of it, we can continue to move the brand forward and continue to innovate with different products and services.
So perhaps Aaradhana, you wanted to...
I was thinking, I think trademark protection is ever more important during this pandemic, because supply chains are coming into limelight. Supply chains were never in limelight. It's just the trademark. The function of the trademark was to just associate a product with the originator. But now it is, in addition to that, the supply lines are also coming into limelight. And then there have been many reports of counterfeit usage of the counterfeit trademarks in the context of supply chain. So I think that is something which this pandemic has kind of thrown up for the trademark owners to defend.
So almost an opportunity perhaps for some other unintended parties. So something to perhaps a little more uplifting. Heather, what are some of the opportunities and solutions that brand owners should weigh or otherwise consider?
Definitely. Yeah, I mean, I think really it goes back to just finding ways to be innovative during this time, somehow to find a way to make use of your products, their services, while preserving IP rights, but also making sure that, you know, whether or not whether this is, because of course this is not going to be the last time that we experience some sort of pandemic or some sort of economic impact to a business or a brand, and that subsequently, you know, at the same time, simultaneously really impacts the IP space. So I think it's, you know, so important for brand owners to kind of innovate throughout this time and see what might happen in the next 5-10 years, and how can I prepare myself for those instances, and maybe use this period of time as like a testing center, and, you know, see how I can continue to keep the brand and the business alive.
Yeah. So it's almost playing a little catch up with the times, given the sort of new curveballs that we're continually thrown. I think at the start of the pandemic, it was, and no one expected it to be of this impact and magnitude. And then, you know, before we knew it, we were all in lockdown mode. And I have to say that the vaccination programs have been rolled out a little faster than I personally anticipated. So again, depending on the pace of the implementation of those programs, we could very well be looking at the old normal again, fingers crossed. So perhaps I think with that, I'd just like to ask Aaradhana to perhaps talk to us again about patent prosecution and protection.
Yes.
What are some of the, I think, the opportunities that you're coming across?
Okay, the first one is the wise use of resources, because, you know, we don't really know. Every day, almost every day, you hear of a new strains coming up and hitting the population. So which means we are not returning back to offices very soon, which means, of course, you may not have full strength into the labs. There's a possibility. It's not that, you know, there's a possibility people may just be at home. So that means that you have to get into the thing that wherein you can preserve you can stretch your dollars basically. So you use trademarks, use your know-hows, you do your market research, take time to chisel your saw, for example, or just go and get into documentation, you know. And the second thing is that get into the research fields wherein you can do something about food security. For example, vertical farming, aquaculture to ensure availability of food, supply chains, processing of vaccines, medicines, diagnostic kits. Invest in relevant AIs to minimize exposure to harmful chemicals, for example. And also, what you can do is look into entering useful collaborations, because I think everybody has got limited resources. The manpower and everything, so it's best. And the trend that is coming up is actually go for you know, collaborations. Even I see yesterday in the news I saw even unlikely partners are getting into collaboration. For example, Starbucks is joining vaccine mission. Uber is kind of free rides to healthcare workers, which you know all, of course, about. And the Microsoft is into providing database expertise, and some other firms are into healthcare expertise. So that's a growing and good positive trend coming out of this. Earlier it was there, but it was not so much. Then the second thing is that the companies are getting into vaccines, diagnostic kits, food security, aquaculture, and AIs to perform human tasks like staining of enclosed spaces. For example, I saw this robot. It was actually using UV rays, UV to actually you know, sanitize the enclosed spaces, the malls and all, after everybody's kind of gone home. So those ones are very positive developments. And another trend which I'm seeing is the high tech is kind of slowly getting replaced with the simple functional invention, like everyday inventions. The trade secrets are gaining grounds. Protection by registration may be challenging in these times, because you want to stretch your dollars. And very simple inventions, like they may fall into very crowded space. So you may not want to go for patent protection because it's expensive. So open collaborations may gain grounds. Generating IPRs also can be very, very challenging from super simple inventions. So I think trade secrets and collaborations are kind of in the central stage. And of course, we have been talking about patent pools, patent pledges, etc. They may gain popularity, but It's just that we are not seeing anything coming out of that. Ever since the pandemic kind of started, everybody is talking about patent pools and patent pledges, but nothing much is like happening. And what I gather from the media is that the sharing is there, but that sharing is not enough for people to come up with something tangible, to help the population, to help ease the pandemic. So what I foresee, I may be wrong, that registrable IPs may phase out in the favor of heavily collaborative research, forced by the need to pool available research dollars and need for simpler invention that can provide solution for our everyday lives. So trade secrets and collaborations, that's what I see moving.
Yeah, as you were speaking, I think it sort of sparked up a few thoughts in my head. I think it's true, absolutely, that collaboration is key, given that united front and defense is what's required to fight this virus. But unfortunately for me, who has been in the dispute space for so long, you do sometimes have hiccups on the road of collaboration, as unfortunate as it is. And I suppose the question is, how do you resolve it in a fashion that works out for everyone in question? And this leads me to the topic which is very dear to my heart, IP, arbitration, and ADR. So I think first off, it's quite a trending topic. And, for many, many years, it's sort of been receiving a little less attention due to the obvious impediments of adopting consensual dispute resolution processes. So when we're talking about situations where it's a rather aggressive strategy that has to be taken in fending off, for example, patent trolls and the like, a consensual dispute resolution mechanism is clearly not going to work, depending on the counterparty in question. But when we're talking about collaboration, clearly there is the will and the heart to work together, but unfortunately issues arise. And very often, I think, in the desire to get the projects running quickly, perhaps certain details are not fully discussed. And for very, very good reasons, because you want to park certain issues to be able to drive the progress. But obvious examples where collaboration might run into certain roadblocks, for example, if you have a very successful product or the result of collaboration, then there's obviously questions as to ownership, level of contribution, rights to sort of use, exclusivity, and monetization, etc. So with that, I think, speaking as an arbitration practitioner, the obvious upsides to the consensual dispute resolution processes, such as arbitration, first of all, is that it would be, when you're talking about multiple proceedings or jurisdictions being involved, if you have a cooperative counterparty, you can consolidate it into one forum. So instead of having to fight it at multiple fronts, it's all consolidated at one forum. The second thing is, if you pick the right forum, and that's a very important caveat, it would be a neutral forum where parties feel confident that the correct or at least a just result is reached in the end. But at this point, I'll just add a point that, look, very often, especially for arbitrations, you do have parties amicably settling before the award is issued. I think it's just inherent in the process, which allows parties to perhaps be a little more forthcoming and amicable with each other and trying to broker their own solutions rather than have one imposed on them. The third thing would be the proceedings can be tailored so that instead of having to deal with perhaps onerous discovery processes or countless rounds of expert reports, etc., parties can come together and decide how much discovery is going to be required and how much, for example, expert input might be required. The fourth thing clearly is confidentiality. That's a very well-known and inherent trait for arbitration. So especially when you're at that cutting edge of technology, you do not necessarily want the details of your product or invention to be out and publicly available through court papers and the like. So it works to both parties' benefits. And the fifth, which I've mentioned earlier, which is the preservation of commercial relationships. Yeah. Now, There are some which I consider a little more neutral considerations, which is emergency reliefs. Sometimes injunctions, unfortunately, are necessary. And it's been said many times that emergency relief is available in arbitration, which is correct when it comes to, depending on the type of arbitration institutional rules that are selected. But to me, I think it's something that's easily available through court as well. So maybe at this point, I'd like to invite my fellow panelists to maybe share any experiences that you have in terms of getting injunctions and the like in the context of, I think, local litigation proceedings, because I feel that this is a point which is really evenly matched across ADR and litigation options when it comes to IPR protection through dispute resolution. Good. Lily, would you like to go first?
Yeah,
Oh,
sure.
yeah.
I mean, I think one of the things that I wanted to highlight, especially when it comes to, I completely agree that I think collaboration, we're going to see a lot more of this. It seems to be the buzzword at the moment, actually, certainly amongst organisations. It's all about collaboration, working together, engaging, driving towards common purpose. So this is very much the catchphrases we're hearing. When it comes to things such as injunction, you very rightfully called out that one of the things you need to be aware of is, people may not necessarily fully consider all the issues. And especially when you're talking about joint development agreements and arrangements, one of the issues that often arises is taint, whose matter is, whose idea is whose and who's contributed what to what and what is the value of that. We're talking about injunctions. What people tend to fail to realise is that it's not necessarily a straightforward process to actually go to a court of local jurisdiction and seek an injunction in relation to a matter which you may need to be injuncted. And I think that's something which not only practitioners, but, general population doesn't quite appreciate at all times. It's very important that if you feel there might be a need to go down that route, that you have taken the steps at the start to actually do the homework to make sure you do have the basis on which to actually file for the appropriate injunctive relief. So, in my experience, when you have to file in front of a court, which, the first step is actually to apply for an application for relief for your injunction application to be heard, they're going to be asking you a number of questions in relation to, ownership, rights of use, quantums of damage, amounts of contribution, evidence. And it all goes back down to evidence. What sort of evidence do you have in terms of substantiating your case before the matter will be even heard for consideration as to whether or not injunctive relief, category can be met? So, I mean, it's these kinds of things which I think people need to really consider when you're talking about injunctive relief. When we look at the issue of arbitration, I completely agree that, especially when it comes to cross-border international matters and where you have matters of highly confidential nature, which you don't want, the substance to be disclosed to public, arbitration is the best route. But having said that, one of the things to also balance is, I guess it depends on the value of the actual investment that's behind that, because arbitration can be a costly exercise when you compare that to, for example, to a standard litigious process. So I think there's probably just a few practical considerations to bear in mind when you're actually thinking through the arbitration versus litigation route, and especially when you're thinking about these routes in relation to IP. For example, to commence an arbitration in Singapore, the filing fee is 25,000 Singapore dollars upfront, and some people may think, oh, gee, my matter's not worth that amount, so even for the filing fee, so you just got to think about those nuances when you're actually, looking at what sort of forum you would like to pursue.
Yeah, for sure. I think cost is always a key consideration, and timing as well. Cost really depends on, which institutions that you're looking at, which courts you're looking at. And like you say, I can't emphasize and agree enough with you that ultimately it goes to the evidence. Because very often, I think the business units could feel quite emotive. And, to them, they think that there's obviously a strong case to it. But when you drill down to it and you start drafting the necessary papers and you start asking, so who's going to be, signing off on this affidavit? And you have to check and counter-check the basis for the injunctions. That's when, I think people tend to be a little more circumspect. But certainly it is an option that's available, I think, in the right cases and to be, sort of prosecuted accordingly. Heather, would you like to share some experiences from the US?
Yeah, I mean, for me, most of my work is really centered around technology transactions and, data privacy matters and security. And I think, more so not necessarily in the context of like arbitration from my end, but I think especially with this field, there's so much interrelation between intellectual property and even with data privacy and security. And with so many people working from home, of course, there's a lot of issues that come into play with, bring your own device to work, or, employee security using your own Wi-Fi networks and devices, and transmitting such intellectual property information across those networks, and making sure that the entities and employers are actually encrypting that information, making sure that anything that's going from one party to the next, whether it's domestically or even internationally, are being protected, and that we are adhering to those standard contractual clauses and GDPR and CCPA regulations, just to make sure that at the end of the day, we're not, essentially releasing that information to the public.
Yes, I'm so glad you brought up data protection, because increasingly it's quite tied to IP protection.
Right.
So it being sort of a element, I think, a building block towards it, and it's sort of a recognition also, not just by the regulators, you mentioned GDPR, but also by the courts as well. So like I think Mr. Kang mentioned at the keynote address, the change in the Singapore position, which is I think signals a more pro-protection approach, in the presumption that there is a breach of confidence unless the presumption is displaced. So it looks almost as if that there is a nod towards the need to protect the inventors, the creators of the original product or IP, and sort of tightening the protections around it to the benefit and encouraging more innovation and the like. Aaradhana, would you like to add anything?
Yeah, recently actually I had a very interesting case. Before we had to decide, there was a lot of data, and the data was not ready for protection. So we had this question facing us: how to protect this data? Data is not something which is like registrable or even protect as a confidential information, because people need to publish as well.
That's right.
They're running out of time. So it was very difficult for us. Then eventually we had to decide that, okay, let us file patent applications like section by section. So we had no alternative, because one side, inventors, they want to publish. Another side, institute wants to file a patent protection. So how to find a balance? Earlier, I think I was in IPBC Tokyo, there was a talk about protecting data like databases as and recognizing databases as a species, independent species of IP. I think that would be very crucial and very important for R&D institutes like us. There should be a way to protect data as such, so that we don't have to, we don't find ourselves as the crossroad of, should we go as a confidential information, or should we go as for filing a patent application, or what about publication? So these are very complex and intertwined, issues that sometimes we face. And these days, because of AI and there is always AI angle to many of the inventions. So you would see that there is a generation of lot of data, which we have no idea how to protect it, because publication is a must for all R&Ds and academic institutes. Actually, publication is a must. So finding a balance is very hard actually. So we end up we just had to file a patent application for that segment and hope that there will be further developments, and then we will incorporate all the new data at the point of PCT filing or non-PCT filing, the 12 months deadline. So it was a very difficult question for us to address.
Yeah, absolutely, because there's an inherent tension between the two routes, right? You either go A or B. You can't do both. And it's because also it's a new form, it's the new way that we're doing what databases essentially that you're talking about, because there's no agreed on mechanism for protecting it. And so you're resorting to the traditional models that it doesn't quite fit into. And it sounds like in this case, you went for the publication and the patent.
Yeah, patent, because that's the way you can ensure publication.
Yeah. Sure.
So it's like dealing and managing different expectations of different parties is can be very difficult at times. You really have to very tactfully manage that. Okay, you want this? Okay, we'll give you this, but have some patience.
So perhaps just on that topic a little longer, because look, it's going to be in terms we know that you eventually went for patent protection. In terms of the jurisdictions that was ultimately selected, because it would be very expensive to just go for all and sundry.
We had to go locally.
Yes, so it was just local.
Just locally. Yeah, we do file overseas as well, but in this case, we thought it would be best if we go local first.
Sure.
And then we will have 12 months to decide about the further opportunities. As the things are not really ready for the market, right? It's like just like data is just, from various institutes, you have the data coming in, and this is the best way to preserve it. Yeah.
I raised that because in one of the cases I handled before, it was a technology transfer agreement in relation to a product that was being sold that was state of the art. So the transfer agreement, I think, had quite good provisions, but they were dealing with a counterparty, which I shall just describe as a high-risk jurisdiction, where replication is extremely rife. So in that case, we had to look at the contractual provisions for protection. It did provide for arbitration, but as I mentioned earlier, arbitration part of it is consensual, and where you can get an award and enforce against them under the New York Convention. That would still take a little time. And the other conversation we had was, look, what sort of patents filings have been, the registrations have been made? What sort of protection are you looking at? And for some strange reason, I'm not sure what the issue was, but patent protection was filed for in the country of origination, so the inventor country. But for some reason, not in the country where the product was being sold into.
Yeah, because it depends. You see, at this point in time, when the data is just being generated from the different sources, you don't really know what the final product will look like in the first place. So you go into a jurisdiction which you are most familiar with, and definitely you are most familiar with your own local jurisdiction. So eventually there is a product inside or starts shaping up, then you think of marketing and everything. So that's some practical considerations there. And of course, you want to stretch your dollars.
Yes, absolutely. So I think some issues that become very apparent or obvious on hindsight are sometimes not thought of throughout the process, because when we raised the question, was patent protection filed for in that other jurisdiction, there was a pause. I think the realization was that obviously it should have been done, but for whatever reason it was not. Then there were questions as to, is it too late to do so now, etc., and it's just, I think, a thing to take note of. Now, I think we've talked quite a bit about patent protection, and also I think recognizing the point that really it speaks to the limitations of ADR as well, because even though it's consensual, dealing with certain parties, you do need to resort to the local jurisdictions, IP officers, protections, registrations, etc. And on that point, I suppose would it be possible for perhaps our panel here to share maybe some experiences in terms of registration, any particular issues or previous case studies that you think would be especially suitable for us to share, I think, in the 5 or 10 minutes or so that we have left.
Okay, I would like to share something because we had circuit breaker, right? It's like being in the prosecution space. I was hoping that perhaps patent offices around the world would extend, for example, the 12-month deadline, because it's not extendable. But actually, that should have been extended, not just for the period of circuit breaker, but even beyond, because people need to be in the lab, they perform the work and, churn up data. And then it has to be decided whether it can be included in patent applications or not. But we didn't see that. So that is something I think patent offices could help. But of course, but that's a trend all over the world, not just in Singapore. Singapore has been very good in supporting, the applicants. But just we thought that 12-month deadline could have been extended, like maybe 6 months or so that people could, especially in the field of biotech, when you have to be in the lab, you have to perform your experiments, and then you have to see whether there is something, useful coming to coming from the data and all those things. So that's what I thought, that perhaps extension of deadlines beyond 12 months could have been, thought of.
Yeah, I mean, it will be quite consistent with how governments and regulators have been acting. So for example, I think in the data privacy space, in Europe at least, I think COVID-related discounts have been given for penalties that were levied in relation to, so for example, data breaches and the like. I think in recognition of the hard times and difficulties that businesses are facing. And of course, in Singapore, we have also the COVID temporary measures relief act.
Yeah, and we also have this earlier, if you remember, last year in the May, there was a scheme for SGIP fast or something. It was to fast track all the COVID-related inventions, as well as the other technologies as well. So there was a means of fast track was provided by the IP office, which is quite good, because diagnostic kits and all, you could always fast track. So that was a good measure coming in from Singapore. Yeah.
So perhaps at this point, I'll just issue a call for any questions to any of the participants in our session to please feel free, and I'm sorry to my fellow panelists, to pick the brains of my fellow panelists if you have any burning questions for us. Perhaps, Lily, do you have any other sort of observations regarding IP protection in these times that you'd like to share?
Yeah, I guess maybe a closing observation from me on particularly the prosecution and protection side. I think one of the areas I did want to raise, especially because we've been speaking about it now in the context of protection of, inventions, trade secrets, NDAs and things, is really, what challenges the COVID situation has raised in relation to the ability to closely monitor and review the activities of your own people, especially when there's limited ability to encounter, individuals face to face, or even to be on the shop floor with them, so to speak. So, I mean, from my own experience, I have to say that pandemic has, or at least appears to have provided an opportunity for those opportunists who might otherwise have access to competitive information, such as trade secrets, to quietly exit the business and say join a competitor, or to set up, a competitive outfit. And this is where I think it's really important to make sure that cross-functionally the businesses, do their audit and sense check in order to assess and understand where their key hotspots are, including opportunities for leakage. And this is where it then comes down to making sure that, hand in hand with your IP protection regime, you have in place, very robust employment agreements which have your clear, requirements with respect to, confidentiality, IP ownership, competition, and also making sure that, your contracts are really realistic when it comes to the ability to enforce, and for example, we had a matter in Thailand where, the law doesn't take a position in relation to non-competition, but the courts have held that they are enforceable. But, the challenge to that is to even get, before you can even get your matter before the relevant court, it takes already a year to do that, which is likely to be the maximum duration of your non-compete. So when you get there, the court, although it can take a view that it's enforceable, it's possible that it's going to take, there's no damages awarded without a liquidated damages clause. For us, it was really sort of, I guess, sparked in us, the necessity to start reviewing our overall processes in terms of how we actually are monitoring and ensuring that our own information is protected vis-a-vis our people, and how do we do that in a context where it's not so easy to be closely in touch with those people and understand their movements.
Absolutely. So the other, I think, key point here really is that the need to control the internal environment. Like you said, right, the risk for leakage is so much higher with less control over the work environment and the workplace. And I've also heard from my other conversations that that's one side to it. And the other side to it is perhaps a little unrelated to our topic here, which is an increase in whistleblowing incidents, as employees have more time to sit back and consider other non-usual matters. And you're right. I think it's extremely difficult in terms of physical means to control that, which was previously available to us. So there is more of a pressing need to shore up the legal means of doing so, making sure that, that the employees understand the kind of obligations which they have.
Absolutely.
which again takes us, I think, to the earlier case that was mentioned in the keynote address by Alvin Kang around the protections, that essentially the decision was one which was very much in favor of the former employer, issuing, I think, quite a strict warning to employees as to the kind of information which they feel they can just carry away with them. Now, Heather, I'd just like to ask you, given that we have a couple of minutes, but I just noticed a question by Jared. Can we still appeal if we don't agree with the award set by the arbitrator? The short answer is it's very, very, very difficult to do so. I think one of the key characteristics of arbitration is that the award is intended to be final. So there's usually very, very limited grounds for appeal. There could be, I think in the arbitration space, there's a difference between appeal and enforcement. Mm-hmm. So appeal is when you say the award is wrong, the decision should have been a different one. Enforcement is, for example, if the defendant is asked to pay damages of, let's say, $10 million, and they refuse to pay, then the claimant has to start chasing and enforcing around the various jurisdictions where there are assets to get satisfaction. And at that point, the defendant could say an award should not be enforced, for example, in Malaysia, because an award that's issued in Singapore should not be enforced in Malaysia because, for example, it's contrary to public policy. That's one very, very famous ground, or because there is certain illegality or the tribunal, for whatever reason, was conflicted or corrupt. So those are the usual grounds. But the short answer is that your usual litigation appeal would not be an option. So sorry, back to you, Heather. Any closing observations for our participants?
Yeah, I think it was really important, especially what Lily was just mentioning, especially with employees and maintaining those NDAs and to really maintain the confidentiality, not only of your data, but overall of the organization's trade secrets and operations, and really being able to monitor what employees are doing, not only before, but also during and after the scope of employment. And I think it goes directly to the heart of making sure that in those agreements that there's those provisions as well for the period of time in which they're not going to be actually going directly to a competitor. And even in the instance that they might go to a competitor, that then that competitor will have to pay some sort of retribution or some sort of compensation toward the prior employer, just to make sure that, hey, if you guys are taking the individual on, you're also going to suffer in some way monetarily from that. So I think it's just making sure that those contracts are as solid as they can possibly be.
Mm-hmm. Thank you. So I think not much from me. I think just to recap, we've had very useful observations from our fellow panelists dealing with the pandemic-related logistical challenges. And I think one key thing around there is to be agile, be nimble, go onto digital platforms if possible, and manage expectations of stakeholders. Looking out actively for new opportunities, keeping use of the trademark and the brands, even under difficult circumstances or challenging times, so that you don't lose the future ability to do so. I think on the patent prosecution front, or rather patent protection front, there is an inherent tension between publication and also, being able to make use of the confidential information route to ensure that one is able to protect the products accordingly. And just keeping a lookout for, while collaboration is the buzzword and obviously absolutely critical to how we can move forward from this pandemic, to look out for potential pitfalls as well. Now, I think we just have a question here from Mr. Saraf. His question is, as a generic company, how can they start arbitration prior to approval and launch? Thank you. It sounds to me that the question, when you talk about approval and launch of products, it would be more protection around the patent space, although I'll invite my fellow panelists to chime in with comments. So when you're talking about a protection as against the world, arbitration is not a viable option, because arbitration at the end of the day is consensual. So for example, if parties A and B have an agreement, then you can go for arbitration. But if you're seeking to protect your product against the entire world at large, then that's not going to be possible. You're going to have to go down your usual routes of IP protection within the various jurisdictions. But if it's a R&D or collaboration agreement that you're talking about, then you'll be making sure that the arbitration provision is written into the contracts, and then you can use that as a contractual mechanism to get any arbitration agreement. And if you want to start arbitration, it's really as simple as filing the notice of proceedings to the counterparty and also to the arbitration institution. I see we have a clarification. It says in trademark. So Heather, I think we will need some of your input here, but I will say that as far as trademarks are concerned generally, because there's mass implication, it's not one of those that would be especially ripe for a consensual process. But perhaps you could add your comments too.
Yeah, and if I could, if they could rephrase, I'm just looking here for the question. Maybe I'm not seeing it in or I'm in like a different chat. I'm not really seeing that.
At the bottom, so I'll read it again. It says, as a generic company, how can they start arbitration prior to approval and launch in trademarks?
Oh,
that's actually a...
So I think...
clarifying question for the author, but I guess in order to fully appreciate, we'll probably, certainly from my perspective, I would want to understand what would be the purpose that you would be wanting to launch the arbitration for. Obviously there needs to be an issue at hand, and as Lijun explained, arbitration is usually a consensual process. So perhaps, I'm not sure, I'm just reading between lines, maybe it's a question relating to how do you protect your trademark before you've gone to launch to market through the usual means? I mean, I don't know. Maybe it's something that I'm seeking clarification on myself. It seems like it's a strange, I mean, it might be just the way the question's phrased, but it doesn't seem that arbitration would be suitable for this type of issue.
Yeah, so for arbitration, again, you do need a contract with the other side before you can start arbitration at all. Any trademark arbitration issues I've dealt with would usually be, for example, if company A has acquired company B and all of its products and the like, then if the SPA provides for an arbitration provision and company B continues selling the products, which they shouldn't do under the contract, then you would be able to launch arbitration. But against consumers generally, the answer, I think, is no. So Mitali, I think you have just given us a stop signal. Well, unfortunately, the session has come to an end. And I think for Mr. Saraf, if you don't mind, perhaps we can take this offline. I think just being considerate to the upcoming panel sessions, and then we can continue.
It's on the chat box. Just to answer her, you can write down on the chat box if possible, and I think she will get her reply. Okay. So thank you to the key panelists. Thank you for everyone for a wonderful session in the starting of the conference, a panel discussion, and so much. Thank you, Lijun. Thank you, Lily. Thank you, Aaradhana and Heather, for joining for this wonderful session.